people using social media reached over 220 million, or 82% of the U.S. population. So basically everyone is on social media, but we knew that. In today's digital age, information spreads like wildfire. And that is the crux of a cert petition before the Supreme Court right now. Could a juror's social media activity be a source of influence, even unbeknownst to them, in a public trial? Here to talk about the growing legal intrigue about social media and jury bias is our dear friend Elie Mystal, a justice correspondent at The Nation. Elie, thank you so much for coming back on Amplified. And just to offer a little context here, back in 2018, a former justice, Alan Lawfrey, was convicted. Alan Lawfrey, former justice, was convicted of wire and mail fraud. And shortly thereafter, it surfaced that one of the jurors had liked and retweeted some tweets that were actually critical of Lawfrey. So fast forward to now, and his lawyers want this juror questioned about her activities on social media. In the legal world, why does this even matter?
Yeah, so it's a longstanding principle, right? That like if you're a jury in a trial, you cannot have contact with outside forces about the trial, right? You're supposed to just like pay attention to the trial and not take in all this other information, right? In this particular case, the juror was caught after conviction having retweeted some articles that were critical of this man, as well as following a number of reporters who were tweeting about the trial very heavily while the trial was ongoing. Now, you can imagine in the olden days, if like a reporter just kind of went into the jury box and just like, let me tell you everything that's really going on about the trial, the judge would say like, absolutely no, you can't listen to that reporter. And if you do, you're kicked off the jury. But this is social media. And the juror is basically making a Bill Clinton, I didn't inhale kind of defense, right? Like, oh, I followed the tweets, but I didn't read the tweets. I mean, that's literally their defense. And the convicted man is like, come on. That's not, that we don't have to be stupid and believe that, right? And so they've appealed this all the way to the Supreme Court. It's unclear whether the court will take the case up, but I do think that eventually the court is going to have to weigh in on this, because this isn't the first time this has happened. And trying to figure out what the rules are for social media and Twitter specifically, which has this kind of ability to, you follow so many people, you're not literally reading every tweet of every person you follow. If you're a juror, do you have to cancel your Twitter account or deactivate it while you're on the jury, or like what the actual rules are? We could use some high level guidance about what the rules should be. And so I hope the Supreme Court takes up this case. I don't know that they will, because at the end of the day, I don't know that the Supreme Court cares that this particular person was convicted on the backs of a bad juror. As we're seeing kind of throughout our legal system writ large, right? There just isn't a lot of concern, especially by the white justice system, about making sure that juries are fair and equitable to all people who come before it.
Good old white justice system. I find this all to be really, really fascinating, because to me, as we're trying to figure out, does the Supreme Court, well, first of all, should the Supreme Court even be interested in this? Should they care? Obviously, one of them wrote that, Lawfrey's lawyers wrote that extrajudicial information is especially far-reaching in this digital age, and that it can, quote, reach into the jury room silently and without leaving any public trail. So a juror can receive prejudicial contact without anybody, including a juror sitting in the next chair, being the wiser. I find all of this to be fascinating, because we're trying to figure out if we should actually police social media, or what can you do to block people from having information, let alone misinformation and disinformation, which is what's plaguing our election system right now. And it feels to me like we are literally in this pivotal moment where this case is certainly about this particular judge and whether he got justice, or, if it was tainted. But there seems to be something bigger to me brewing with regards to our digital age and how society and the law should shift around all of this. So,
imagine,
should the Supreme Court rule in that way?
You can imagine an attorney kind of sliding into somebody's DMs, right, during a trial. Like, who would ever know? Should that happen? Now, I tend to
Huh.
take a view that the best way to handle social media is to not treat it as materially different than other forms of media, and simply police it the same way we police other forms of media, right? So if a juror is on a big high profile trial, we often sequester the jury. We say that you can't watch television, you can't watch news reports. That happens all the time. Even in a situation where a juror is not sequestered, they don't bring like the morning papers and slap it down in the jury room in the middle of the trial. If there's an article in the paper about the trial that they are on, that's just common sense, right? So if we have that common sense for newspaper and magazine articles, I don't see why we can't have that same common sense for Facebook and Twitter. It would seem to me that the most
Mm.
reasonable thing is when you step into the jury box, you relinquish your phone and you don't get it back
Mm.
until the trial is
Mm-hmm.
over, or at least you have to
Mm-hmm.
deactivate all of your social media apps until the trial is over. Would that be a cost for the potential jurors? Sure. There are lots of things that people find annoying about jury service that we make them do in
Right.
order to ensure, or at least ensure, the perception of a fair trial. I don't see why it would be so hard to make this one of them, but you got to convince justices
That'll be fascinating to
to
follow.
you know
Yeah.
octogenarian justices who didn't grow up with this technology to understand how it works and how it can be used, and that's always a challenge.
Mm. So I want to pivot to another case before the Supreme Court right now, FBI versus Fazaga. This past Monday, they heard arguments involving the FBI and their surveillance of Muslims. Tell us what's going on here. Reminds me of
Yeah, so
COINTELPRO a bit.
yeah, this is one of those examples of just like every day it gets worse, Aisha. Like the case before the
Mm.
Supreme Court that was argued on Monday involves a massive surveillance program really targeted at Muslims, kind of in the post 9/11 crazy terrorism war. Back when white people cared about guns on the subway, this is back then, right? But only obviously if brown people had the guns. So they were surveilling them. They were surveilling them at their mosques, like literally taking photographs of people walking in and out of a house of worship. Can you imagine? Can you imagine the
Oof.
FBI
Oof.
surveilling January 6th insurrectionists as they go in and out of their churches? Would never happen, but this happened to the Muslim community. And in particular, for these plaintiffs, they allege that the FBI was surveilling them in their therapist's office, which
Oh
I,
my
I again
God.
I can't imagine that happening, frankly, to any white person. I don't see how that happens, right? So they're suing. They're saying that the FBI violated their Fourth Amendment rights. The FBI, an argument that was started under Trump and Bill Barr, but has been continued under Biden and Merrick Garland in a way that they do not have to continue this argument. The Justice Department is saying that they cannot be sued by these Muslim plaintiffs because the information they obtain through this kind of surveillance falls under the state secret exception, so that the information is essentially too sensitive to be released at trial, and thus the plaintiffs cannot, so that the FBI is essentially above the law in this particular situation. Now, the Ninth Circuit Court of Appeals have said that's ridiculous. These laws, the FISA law, the Foreign Influence and Surveillance Act, which the Muslims are suing under, was designed specifically
Mm.
to stop the FBI from doing things like surveilling Martin Luther King on his phone taps. Right? It was designed specifically to stop this kind of bigoted racial profiling by the FBI. How can it now be used to prevent these Muslims from getting justice? So the Ninth Circuit said that the court could hear the argument behind closed doors in a closed door session, so that if any relevant state secrets were involved, they didn't become publicly available. That was the Ninth Circuit's argument. From what I got from the argument in front of the Supreme Court, five conservatives were like, nah, that's too hard. We have to protect the FBI, we
Mm.
have to protect these state secrets, and we have to deny the right of these Muslims to sue for their own rights. One of the things I always try to point out is the fundamental hypocrisy of the conservatives, right? So let's just rewind to last week when
Well,
Justice Alito was making this argument that Texas could pass these laws to get around abortion, the constitutional right to abortion, right? And he was making the argument that
hmm
a state could create a cause of action that literally anybody could sue under, right? Now, fast forward to Monday's
Except for
arguments
now,
about
yeah.
this, right? And all of a sudden,
Right.
no, you can't create a cause of action to sue
No,
the
you can't
state. That would
sue.
be wrong, right? I mean, it's just he's like the scarecrow
Well, I also,
in the Wizard of
before
Oz,
we run
only
out
an
of
evil
time,
version.
before we run out of time, Ellie, I just want to make the point, too, that these people who were being surveilled weren't really found to be doing anything wrong. And that's what's also interesting here. And in fact, it was the FBI agent who essentially was posing as like a sleeper cell, started to talk about jihad and like using all this rhetoric that the Muslim community was like, oh, who is this crazy person? And their community leader called the FBI on him, and he was the plant there that was stirring up all this mess. So it is interesting in this case because, you know, we'll see if regular, ordinary, you know, citizens, people who are praying, actually get justice in all this. Ellie Mistel, we're going to keep watching this. Justice correspondent at The Nation. We will keep reading you. We appreciate you being here to break all of this down and look forward to seeing you soon again here on Amplified. Thank you.